G'day, Grant. Thanks so much for joining me on the podcast today. I appreciate the offer, mate.
Always, Ben. Love working with your firm, and it's great to see that you're putting out some great content for accountants across Australia, because it's certainly interesting times.
It is. I think we need heaps of support at the moment, and it's just one way that we can help other accounting firms.
Yeah, well, definitely. Well, the tax office isn't helping anyone at the moment, so it's probably people need to support each other. I think is really crucial.
Yeah, yep. And I'm looking forward to diving into some strategies. You're one of the people I've learned so many different things that we've helped our clients.
Yeah.
Especially
always learning, mate. So I think one of the things to be successful, you always need to be learning. I just read a 250-page book on the weekend, just on estate planning, and it was basically looking at trusts and all that. Although I know a lot, it's good to actually go through, reaffirm your knowledge, but then you just find, because you already have a good background, you then find these little tweaks or these little nuggets in there. You think, oh, I've never thought of that before. So yeah, some great stuff out there, but you've always got to be learning.
Yep, absolutely. And before we get into the meaty stuff, would you be able to share what you get up to outside of talking with other accountants?
Yeah, so that's basically my whole reason of being is, just talking to accountants. So what I like to do is I spent a long time, I saw SMSFs were going to be really, the way to go, going down the track. And had a big hand in building up. It was pretty gruesome at the start of right at the start. I was like almost the lone wolf talking about SMSFs, but then set up the association. The SMSF Association was previously the SMSF Professionals Association, because people need a home to actually feel as though they are a specialist, and developed Australia's first ever course in that area. Helped write all the competency standards for financial planners, and so SMSFs was a big part of my life. And look, everyone's had one that's done really well, but it's obviously going to, with budgetary stuff. I think last year the SMSFs cost the government $22 billion in refunds of franking credits, and so they didn't make any money out of it. And that's going to switch. But we're also seeing, younger people now jumping in when they realise, this year, next year, they're going to look at their estate, their balances from their super funds and go, well, why shouldn't I do it myself? But that means because we've got a Labor government, there's going to be a huge backlash against SMSFs. So a few years ago, I sort of plotted, just had a chat with my mum and all that. And she said, look, I want to make sure that everything goes to my bloodline, and that sort of just tweaked in something to me, because I was in a blended family situation then. And since that time, we've just been building up resources and knowledge, and I've always been doing estate planning, but now that I see that wills virtually are, it's not even worth the paper they're written on, because of family provisions, just building strategies and ideas, and that's all led to a lot of planning for bloodline. That's led to, developments of new trusts, styles of trusts. And we've got some more exciting ones coming down that are backed by ATO rulings. And then, the succession planning, which generally, to me, is probably the most fundamental part of any client's affairs is, what happens if mum and dad die together? And, what happens to their businesses? What happens to the whole stratum? Like, for example, I just got a question today, is that if there's just a single trustee and single appointor, and we've actually dealt with this recently, what happens if they die? Who's actually going to run that trust? And we've got a fallback position where it can be the executor or the EPOA can come in if that's the appointor of last resort, so to speak. But most deeds don't do that, and that's just, again, it's a falling in the process. Of course, the smartest thing to do is have that line of succession. But look, we talk around that, Div 7A, Section 100A. So there's always stuff coming up for accountants. A lot of the stuff is over sensationalized. And
you're talking about sort of media stuff.
Media. If you have a look at a lot of the media stuff, it's always focused on the negative. We prefer to. I think the negative is important, but it's got to be, well, if you're going to go out and talk the negative, there needs to be a solution. And we find in the industry that although we've got a law firm, we don't talk. We talk about the negative, but we've got solutions for it. Whereas there's a lot of legal firms talk about the problems, but then there's no real solution, it's quite pointless. And so accountants become very confused. And it's not that confusing, a lot of the stuff. Like Section 100A is, the commissioners just had another loss on that area. I know. So for us, I set up, again, in this succession, asset protection, estate planning space. We saw there's a great opportunity there for accountants to do a whole range of specialisations, and it's a lot easier than SMSFs. SMSFs are probably about 8 or 9 out of 10 to learn because there's so much legislation. Whereas if we have a look at the SAPEPAA space, that's that succession, asset protection, estate planning, it's more dealing with families and finding out what families want. For example, I just got off the phone only about 10 minutes ago, and it was a lady who was referred to me by Accountus, which is one of our advisory firms.
Yep.
And she said, "Oh, my dad's 95, was a POW, thinks he's had de facto for 20 years, left her out of the will, thinks she's going to steal everything." And this lady was a daughter who was going to get 100% of the will and was the executor. And I said, "Well, you've got a couple of problems there." So the first thing is, I can get one of my team to go and visit him, but you have to get a testamentary capacity certificate, because if he's got even the slightest bit of dementia, it doesn't matter what you do, they're going to throw it out of probate. And we've seen that happen, particularly if anyone's over like 75 or 80. So I said, but the main thing there is that if he can't change the will because of testamentary capacity, we can do other things using trusts with your EPOA. But again, if he died, today, you're in big strife, because she'll find a no-win, no-fee lawyer. Probably it was a $4 million estate. She'll end up with maybe 1.5, and it's going to take 5 years to litigate, and it'll probably cost $400,000 in litigation fees. And I said, you as executor are going to be in the firing line. So this is happening all the time with accountants, and it's funny because those accountants have been through our SAPEPAA course, or the one that I train, and go on to become board certified. They can never look at the clients in the same way again. And I'm sure you're the same, Ben, is that suddenly once you start talking to clients about this, their eyes spark up, that they really want that solution of protecting family wealth for bloodline. That's a really high priority for them, because you don't want to see it dissipated in legal fees and the whole family falling apart.
Yeah, absolutely. And maybe we'll kind of talk around this a little bit more. So let's say, like, you're pretty confident that wills are basically useless, or definitely not the trump card when we think succession planning and estate planning. What are some of the things that advisors need to be aware of, or the other tools when working with clients of how we protect, especially those blended families?
Yeah, so in fact, it's quite apt. I think in November I've just set down an hour-long webinar, and maybe have a look at that. I'll flick you through the link, but you can always just jump onto lightyeardocs.com.au, and you'll see there's an events page, and the webinars are free, but I'll be going through all the various strategies for blended families. But in a nutshell, it doesn't matter whether you've got a blended family or not. The issue is that if there's one child or a de facto spouse or even grandchildren or someone who wants to raise a bit of hell, Australia's got the most liberal will contesting provisions anywhere in the world. I was having a chat with our SAPEPAA conference in Fiji, which is coming up. So we chat with a Texan lawyer, and I'll tell him about our system, and he just said, he jokingly said, over in Texas, if you have your will, that's it. It's very, you can only contest it for, undue influence, and their system's very much the same as ours. But whatever's said is said. But in Australia, you've got an ability that an eligible person, which is again children, ex-spouses, can you believe? Everyone can have a ping at your estate, and it just simply then it ends up goes to mediation a whole lot. But if it ends up in court, the judge has got probably about, in Queensland, maybe 14 or 15 steps they have to go through to consider. So you're looking like at a 3 or 4 or 5 day session, which is pretty expensive because you're looking about 15 grand both sides of the lawyers. So you want to sort of keep away from that particular area when we're looking at wills. So then the question is, well, let's have a look at what's not in a will, because the will only deals with your personal estate. So any assets that are in your own name, so that a good accountant will always have set up trusts along the way. Companies, if they've got shares, the shares are owned by the individuals, will end up in the estate, and therefore they're subject to a challenge. And even if they're shares in the trustee company of a discretionary trust or SMSF, you don't want them in the estate, because otherwise, that becomes part of the litigation process, which, as I said, is the Supreme Court might be 4 or 5 years away. There's a lot of mediation negotiations leading up to that. And effectively, the opposing counsel, or the person who's making an application for family provisions, their legal counsel would just simply say you can't deal with those structures unless there's a mechanism to do so. So that puts the business, the investment, or whatever. You can imagine if the market's going down and you can't make any sales or disposals. So we have a look at the stuff that's outside. So the classic one is the trust. The trustee company, obviously, as I said, the shares shouldn't be owned by individuals. And we can talk about some solutions around that a little bit later on. We need to put in place, for example, in any company we have, that on death, that there's a successor director. So you can't just say it's going to be husband or wife. What if they both die? There needs to be someone automatically appointed in that process, so you can do a successor director solution. With the trust, again, you want to have that line of appointorship, and it's fantastic that, and most accountants probably aren't, one is most accountants don't read their trust deeds. I've seen a number of accounting firms with 5, 10, 15, 20, 30 different trust deeds, which makes it an absolute nightmare for trust discretion. Also, we can see there that they can last perpetually if you choose the jurisdiction. So even though I've got my family protection trust, or my Abbott Family Foundation, which is my family protection trust, is in Queensland, trustees are in Queensland, the company's in Queensland, directors in Queensland, the appointer is in Queensland. But because we've chosen South Australia as the jurisdiction, the rule against perpetuities, which is the 80-year rule, to when it's required to vest, doesn't apply. And there's, a lot of most smart trusts are set up there, and even some of the big ones that have been set up in other jurisdictions, you can change jurisdiction to South Australia. So there's been a pretty big case on that one. So we look at the trust. We want to keep it for a long time. We can there's some fantastic ATO rulings that most people probably not aware of, but on death of, say, mum and dad, who, really the main persons that the trust is going to be for, essentially that it can then split down to the children. So that, you've got no capital gains tax, no stamp duty, no worries about probate, all of that. I mean, quite apart from, it doesn't matter which jurisdiction, if you think about the will, someone dies, it's going to take 3 or 4 months to get probate. And then after probate, you might have to wait 6 to 12 months before you can actually deal with the estate. Whereas if you've got a trust, it just, it's what I liken it to is, for example, the Queen passed away. What happened within 24 hours? Charles was anointed king. The Crown Estate, which is their family protection trust, their monies that go to the next in line, he took control of it. So all the money from that, I'm sure Charles is going, thank you. He was sort of living a half a life there. He sacked all his staff that was with him as Prince at Clarence House, and now he's got Buckingham Palace. He's got all the money coming to him. So unfortunately, he's a bit old for it, but that just shows you fantastic succession. And if he passed away tomorrow, then Will suddenly, within 24 hours, it just moves to the next one. And you don't see Andrew or Edward litigating, that Charles is the king and he gets the estate, because again, they use that style of structure that you can't have that litigation. So family trusts are really good. SMSFs, sorry, go on.
Sorry, just on the family trust, I think one of the hidden assets of someone's estate, so they're dealt with under the will and contestable, is loan accounts on the balance sheet of trusts that are received to the estate. How do we deal with those?
That's an excellent question. So when we have a look at trusts, we've got to look at good and bad trusts. So the bad trust is if it's got any business, consulting income, anything that can be targeted, essentially is a bad trust. That's why it's probably best to have trading companies, etc., rather than those. And then, for example, we can then set up alongside a good trust, which is like our family protection trust, that we can move stuff into over time. So, for example, shares, or if you've got stuff inside the bad trust. I'm just doing that myself at the moment. Originally, when I set up LightYear Docs, I did it through the trust, which was great.
Yeah.
But I've put consulting income in there, so that's not good. So that was a few years ago. So that's dopey. So now I'm going to move my shares over to my family protection trust, so the Abbott Family Foundation. Mm-hmm. So that'll go over, but I'll be right, because I can utilise the small business concessions and effectively move them over from that perspective and gift them over to the family protection trust. Likewise, so the issue with those unpaid loan accounts, first off, is that the best thing to do there is assign them over to the family protection trust. So get them out of there, assign them over by way of nil consideration. Mm-hmm. Now, the thing about that is that will now protect it from obviously the estate. Secondly, it's a gift, so that's okay. If it's in New South Wales, they might be able to claw it back if it's in with 3 years from the date of death, with the intent of not defrauding, but limiting the estate. But if it's over the family protection trust, then again, it's just an estate there. And what I would suggest there is that once that loan goes over and it's assigned to the family protection trust, if there's assets, it does a registered charge over all the assets of that, the bad trust. And it's not a bad trust, but I'm just saying that the trust which isn't as strong. So that's the way I do it. The other one is, of course, that you could forgive the loan on death, but the problem about that then puts the asset into the bad trust. But look, if you've just got a good plain vanilla family trust, it's just got investments and all that, then have a look at that forgiveness issue there. Of course, you've got to worry about Section 100A, but by assigning the loan, you really haven't got a problem there. So that'll get you around. And Section 100A is like very limited in its operation. When we had a meeting with them going back mid to late 2021 around making a submission. We made quite a big submission at SAPEPAA. Basically said, look, everywhere, if I put family trusts into the ATO website, I get pages, 30 or 40 pages on what a family trust election is. So, do you mean the whole thing is built around family? So why you would actually be trying to take this action? From that perspective is then, the tax office said, look, they weren't going to really release it until the end of 2022, 2023. The problem is the Guardian case came out in December, which basically said, look, if there was no intent at the time that you're building these distributions up, if there's no intent to make any, transfer them to anyone, then clearly Section 100A doesn't work, and it's very limiting in its operation. And then there was the case last year, the last week, the blood case, and they won again there. So
the ATO,
the ATO lost. Sorry, I mean the taxpayer won. So I wouldn't really worry about it to any great extent. But again, quite apart from that, asset protection would say where you started. Why would you leave that out in the estate? Because it's then going to actually bring in the trust, and if the trust hasn't got the money to pay out those, it's just a very dangerous position. So we need even most accountants I see are set up wrong. One of the ones that I've built, and I know you use quite a bit, and it keeps on getting better and better every day, because there's different legislation coming out, or cases, or that is this concept of a leading member trust. So what happens there is when we set up one of these, we start with the line of succession. So for example, it might be my spouse is the first leading member appointor, so focus on the appointor, which you call the leading member. Again, that's just straight from the British royal family. So the spouse might be the first, I might be the second, and then I might have myself or my brother or someone else, or my children, as the third successor appointor. Now, this is really important. Obviously, they can set up the corporate trustee. The corporate trustee, the share should be in the name of the leading member appointor. Now, what happens there is that obviously you go down the track, you'll have the corporate trustee, you can be the directors. On death, those shares are cancelled, and then they're transferred automatically to the next leading member appointor, who, if they're not a director, is automatically appointed as a director and the chairperson, and with complete veto power. So again, it's no different from when Charles ascended to the throne. You're doing exactly the same. Does that make sense?
Yeah. So that cancellation of shares means that assets don't exist, therefore not in the will, not able to.
Exactly. So what you're doing is you're looking at, and this is why it's really important to read cases all the time and keep on learning, because look, to be honest, I've read everything there is about SMSFs, I've written huge amounts of papers on it. But in this area, there's a lot of case law. So we need to have a look at how people are attacking things, see what happens in practice. And then it's like anything, if you know what their offense is, then you build a defense against that, which is really important, because a lot of cases are, started. And, the no-win, no-fee lawyers aren't going to put in a lot of time if they, if there's big walls against them, they're not going to put the time in because they don't get any money. If there's no chances, if there's a limited chance of success, then you're in a bit of strife. But it's not just on family provisions, it's also, for example, bankruptcy. So like, for example, you said that the loan account is sitting out. So we talk about family provisions. What about if there's creditors or family law? I mean, you're in a pretty big position there that under family law, obviously that will be one of the matrimonial assets. So it's a good idea to sweep that up into a separate family protection trust. And also, again, because it's gifted over, there's a 4-year clawback. But that's why it's better to do things now, particularly if you have a look at where the economy is potentially going over the next 5 or 10 years. I don't think, again, here I'm sitting up in the Sunshine Coast, it's freezing. So the whole commitment for the government to go from 23%, which we are now, to 43% reduction, which is virtually a doubling in the space of 7 or 8 years in our carbon reduction emissions. That's a really, really big ask. And people don't realise that means that, probably at least a third or even more of Australia's cars have got to go to EVs, electric vehicles. And I'm sure that you wouldn't, I mean, the up in Queensland, can you imagine all the tradies driving around in an electric truck? It's a very big ask. And so we're going to see that there's a world recession coming around. So that, accountants are actually going to start to see a drop off from clients, which for me, I'm going to say this is an opportunity because it enables them to get that space, because accountants don't have that headspace to really do the succession asset protection space well, but they really know it. They know it endemically. They just need to go down. They need to be trained up a few levels to really make it work. So, the more time they have there, the more opportune, and then the more money they're going to make in helping clients do what they really want. Clients aren't interested in tax and compliance. I mean, it's the last thing they want to do. Now, going back just to that leading member appointer, which you were talking about, one of the things that came out of a recent decision, which I find quite alarming, and I'll just put it out there for all the accountants. This was in Owi's case, Owi's down in the full federal court. There was, again, the same sort of thing that, mum and dad had set up a trust for their children, named each child as a beneficiary. There was a family falling out, as they always do. And then mum and dad, they made 3 different variations to change the appointer, which were held invalid. You can't change an appointer or a trustee with a change of trust. Variation of trust, you actually have to have a change of appointer or a change in trustee. So from that perspective is then they made distribution a couple of years all to the son that they favoured. The other ones were left out. And the court held that, and this is pretty instructive, that when making a distribution, so accountants think resolutions, you have to take into account the financial circumstances of all named beneficiaries.
You're joking.
I know. So they'd heard secondhand about what their financial position was, but they'd estranged themselves from the daughter and the other son. And the court held basically they were effectively stuffed. So that has a radical impact, but it's also going back to the leading member appointer, because we don't name beneficiaries. The beneficiary starts at the leading member appointer. So whoever that person is, that's the person who's the main beneficiary. And if they die, guess what? It moves down to the next one. So by not having named beneficiaries, having that leading member style trust has really added, not only has it added that extra dimension in terms of providing for bloodline and a good line of succession, it now gets around this Owi's case, which is really important. So when you come around, and all the stuff we're talking about now it's been built by Abbott Mourly. We've put it up on LightYear Docs. So all these documents, again, there's a solution there for it, and it's not an expensive solution. So these are the sort of things that we need to keep up to date on, and we can't really close our eyes, because otherwise it's going to get our clients into trouble and get us into trouble as well. Accountants shouldn't just all be about tax. I mean, trusts are brilliant, succession, estate planning, they're good for tax, but we just have to keep our learning up on trust. It's not stuff that, we've picked up on the way from our partners in our firm who probably didn't know much anyway. So again, we can do that. And SMSFs, the same thing is SMSFs, you can pay directly out of a self-managed super fund on death, and that's protected from a family provision claim. There's been a couple in New South Wales because they use this concept of notional estate, which I believe is unconstitutional, but any other state, like in Queensland, if it's paid directly to us or our dependents who, under the SIS Act, are our children, effectively it can't be put up or swept up in a family provisions claim. But most lawyers, if you go and get an estate plan or BDPN, they're going to put it to the estate, which is like, why would you be doing that? Just doesn't make sense, but they don't know what they don't know. So that's where accountants really need to step into that breach. And I mean, for those of you who want to go through and become a SAPEPAA advisor, feel very free to do so. Have a look at SAPEPAA, SAPEPAA, .org.au, and have a look through there. And if you want to do a course, LightYear training group, which is about to be launched across Australia, and come and do my 3-day course, and then you become board certified, which is fantastic.
Mm-hmm. Yeah, fantastic. And I do want to share with the listeners that Grant's training has been like immensely helpful over the years. I think I started following Grant around 2014, 2015, coming along to workshops and webinars. He does plenty, especially through, I think the newsletter is LightYear Docs. The sort of, they're the main invitations from what I've seen. But Grant, you're saying the SAPEPAA course is probably the fastest way to sort of get up to speed.
Yeah, definitely, because accountants know companies, they know SMSFs, and they know trusts. And remember, it's going back to what you're saying, we're trying to keep stuff away from estates.
Yeah.
So we need to use these tools that we have and start to build elements around that. And I think that that's absolutely crucial. But what we want to do is go from a level of having a general knowledge around it to work out how these effectively really work for succession, asset protection, estate planning. Because you know about the tax, what we want to do is build it for the rest of the stuff, which is fantastic, because all the stuff we do, it's not a breach of Part 4A, because it's built with a family in mind. And again, we're all learning on this journey. We've got around about 250 members, advisors now at SAPEPAA. We've got our first ever conference. So it's a growing association in Fiji. We've got 70 people going. So, there'll be a lot of stuff there, because we've got actually a whole morning dedicated to the international side of the equation, because clients have assets in different jurisdictions, might have an EPOA there or an executor over there. So we need to be on top of that. And the average lawyer, there's no way that they would know that they don't have those connections, whereas we do are really important. And I know, for example, you offer like the leading member discretionary trust to your clients. I mean, how do you discuss that with them? How do you discuss that vis-a-vis like a typical discretionary trust that most of us would just get off the shelf?
Yeah, I think in terms of like approaching that, we've got to sort of keep in mind and sort of share the different options with clients, because some, especially when they're starting their business, they may not be interested in the high level of asset protection or see the value in it. Yeah, and often I kind of describe it as you don't see the value until you need it, and then hard to go and retrospectively pop that in at a time of panic. Yeah. So, but there are clients who are absolutely receptive, and they do want the full suite, where you've got the family protection trust, the leading member SMSF, all those different bits and pieces that can really help defend. And I think it's those people who have been through a bit of a battle or a war before, financially, who just go, oh, absolutely, I'd love to. Love to sort of put the defensive.
Yeah, particularly if people have been divorced. And that's another thing, is that a lot of people don't really focus in on it as the next generation is, if it's through a will and you're giving, testamentary trusts are good, but again, these leading member trusts are better if they're inter vivos, effectively that next generation can be protected against family law. And that's a huge difference, because if you just give them like $200,000, the partner could walk away next day, because it actually forms part of the matrimonial estate and make a claim on it. So you've got to be extremely careful on that one for family law, because it keeps on invading further and further down the track of there.
Yeah, yep, that's it. And what I want to sort of ask is, you've got a couple of different membership levels or options at LightYear Docs. for the firms who are sort of just starting out and may not be sort of super confident, do you have a package that kind of you walk with?
Yeah, look, just jump on as pay as you go, costs nothing.
Yep.
Then you get access to a huge library of resources, that you're going to make money out of, and I think that's crucial. Jump along, you'll get access to our webinars, which we have like one every week, which is going to focus in on particular issues. So tomorrow I'm doing successor director. Essentially, if you've got just a single director, corporate trustee of an SMSF, 90% of the chance that the fund is going to go non-complying unless we have a simple solution for successor director, which on the platform, pay as you go, costs like $229, which includes an update to the corporate constitution so you can do the successor director, binding resolution for directors, and also a deed of indemnity that the person who's coming in obviously doesn't want to get all the crap that might have been there. So that's quite a strong package. Normally a legal firm would charge like $19.50 for it. Yes. So there's plenty of upside there for the accountants to make some really good money. And if you have a look at, that's the first strategy I would always look at, because one is, I've seen problems that, we had one accountant who had 3 clients who died at 30 June, and they were all corporate trustees. They were the sole director. And then we had to really do some, as you said, the shit work, the panic work to try and work out how we can put the spouse in as a director or whatever when there wasn't. 2 had a good mechanism for it, 1 didn't, because otherwise you can't do trust resolutions at 30 June. And if you can't do trust resolutions, the fund is, the trust is taxed at 47%. So you've just got to be extremely careful about such a simple solution. And if you're charging like $550 or $600 for that solution, and we've got a really good letter you can send out to the client, it's fantastic, talks about the problems. If the client doesn't want to do it, there's, they'll indemnify you against it if something happens. Yeah. And then if you think, you've got like 200 companies that it applies to, because not just ordinary companies, like if mum and dad die together, there's obviously an issue there. If you've got, like a 70% uptake on a couple hundred companies, 140 companies at, 550, that's a good 70 grand in the pocket pretty easily, and only doing stuff that, believe it or not, ASIC warned accountants about and company directors about 15 years ago. So it's just something that hasn't really caught on, but it's a really important issue. So you can do it through the pay as you go, or the next level up is we have, which is fantastic, accountants. You've got like, I think you can take 200 documents a year. We've got companies, trusts, all these advanced ones, family protection trusts, successor director, a whole lot of other stuff as well, unit trust, shareholders agreements. We've got a suite of over 40 HR documents for your clients. So, there's over 200 documents there that you can do. Then the next level up is our strategist membership, which is, so that other one's $330 a month, which is, you only need to do one company and you're going to be miles in front of one company, and offer the successor director. Every time a client comes in, if it's a startup, absolutely offer them successor director for an extra $550. And the next one up is $795, but the sales guys are pretty flexible on that one. And with that one, you get access to all the estate planning suite as well. So that's all the data captures. So from a legal perspective, if you prepare a will from a data capture, that's not the provision of a legal service. So as long as the client comes in, and if you need be, Abbott Mourly there to help and sign off if you want to pay us for a little service as well. So there's a lot there, lots of training. We're a bit different than the other guys, like the Clear Docs or the Now Infinity. Those guys are actually reducing their documents. We're increasing them. Plus, we've got real support. You can get on and talk to technical or legal people on the way through if you've got issues, and it doesn't cost you anything. So, and as I said, there's plenty of webinars there. We guarantee for our strategist members that there's at least 25 to 30 hours of CPD each year, and that in itself is a saving. So, yeah, there's a lot of opportunities there.
And that's even without going through all the recordings over the last few years. So,
yeah, well, if you go through those, I mean, there's over 200 of them, you know, you're going to be well, truly up to speed. And we've got not many people use it. I use it all the time at the legal firm, but we've got one interview which is called a Mode and Castle, which you can restructure a client. You can upgrade their existing trust to a leading member style trust, their corporate constitution, their SMSF, the same thing. You can put in place a family protection trust. All these stuff we're talking about. You can do an SMSF will. You can do wills with testamentary trusts, which are important. And then there's also ability to do a gift loan back. So we start at the start. It's great to have the assets, legal title, and individual's name, but it's subject to family provisions. So we can take the equity out of them and give them over to a family protection trust and lend it back, so that, you know, our goal there is to keep the estate free of wealth, but it's all protected in family protection. You can do all of that just in one interview, and that in itself is, look, there's nothing else like it in the world. Now, most people don't get to use it, but as more and more people go through the SAPEPAA, you'll get to use that. And that's, you don't have to do them all, you can just tick them off, but it's super advanced. If you did all that for the client, that's about a $15,000 to $20,000 job easily.
Yeah. And I recall you actually suggesting that people do that one on themselves first to see the...
Yeah, absolutely. Yeah, I did. Yeah, I did another one for myself only yesterday. And honestly, it probably took me about 15, 20 minutes to do. You know, I upgraded my trust, you know, upgraded my SMSF, put in place an SMSF will and a will with testamentary trust, and did the protector, which is that gift loan back. And honestly, once you fill in your common addresses, your common parties, it's really easy. And the good thing about the system that probably most people aren't aware is that once you've done the document, you can go back and relaunch it as many times as you want. So that, you know, if there's an issue, for example, we get divorced or one of the kids want to go in, you just go and change the document, bang, just put out a whole lot. And we're very careful about making sure that if you do make changes to trust deeds, that there is no resettlement. So the way the system works is Abbott Mourly signs it off. It comes out as a PDF, so you can't change the PDF. You can only fill in the data fields. And there's a lot of bullet point chart choices as to what you can do. So that makes sure that you're not providing a legal service. And we've got a letter of advice for that if you issue about that one. A lot of this other stuff is we're also through SAPEPAA making submissions to PI insurers to cover a lot of this sort of stuff, so that you know, accountants, you know, doing wills from data capture, and we're going down LightYear Docs will be next year. We're doing a small capital raising at the moment, but you'll be able to send out an online data capture to the client. They'll fill it in and it goes straight into the LightYear Docs system, so that, you know, you haven't even touched it. I mean, it's virtually the client's doing it. You can go in and print it off, and then you're off and running. I've also got some robots that we've built at the moment who crawl over things, so that one of the things I want to do is, like for trust resolutions and investment strategies and SMSFs, that they'll be able to go in, crawl and rebuild a brand new one for this year. Then it'll just sit in your portfolio of documents. You can go through, you haven't done anything, but you've got all these documents all ready for you to go through and send off to the clients as well. So it only means you've got a very quick check. So that's where we're going. And
you're saying it'll read the deed for you, find the relevant clauses, check that they're okay, and then go, boom, here's your draft minute.
Yeah, so they'll do everything for you. So, which is, it's the truth. This is where I wanted to go. And like that big long interview I've said has got up to 35 documents in it. Yeah. It's unheard of. It takes a good 10 to 15 minutes, like once you press to assemble it, because there's so much going through. But now we've actually got robots that go in and check all our documents every day. So what they do is they crawl over, put all little, you know, fake data in just to make sure it's coming out as expected. So that's instead of having a QA person testing it, we've got robots. So now what we're going to do is use the robots for typical processing stuff, that we would ordinarily do. So yeah, it's pretty exciting.
Yeah, wonderful. Very cool.
Yeah, it's very exciting.
And you reckon don't worry about Section 100A?
No, look, again, if you have a look at where it's going, I would say, I know the ATO is taking the Guardian case a little bit higher to the full federal court, and then maybe even the High Court. But the way the judgment was written, it was written on the basis of all these High Court precedents. So it's very surprising that, it was released in December. So the decision was in December and still hasn't gone to, they still haven't made an appeal yet. So I would say that, again, that there's those 5 issues that you need for Section 100A. The first one is that at the time of making a distribution, there was an arrangement in place. So that someone else does to get the benefit of that distribution. So that's the second one. So if you have a look at it, if you've been distributing to adult children all the time and there has been no payback or whatever, get where we started off, assign that over to a family protection trust, because that's not going to be a Section 100A anyway, because it was never contemplated. And the fact it's over in a family protection trust, doesn't mean anyone else is going to get a benefit from it. So you're
saying if you've got a distribution from, let's say, a trading trust or a trust with income to an adult child, you can assign
that. Yeah, gift it over. Yeah, gift it over to the family protection trust, and that's not going to be caught by Section 100A anyway, under any circumstances. So if you have a look at that, and we've put in a private binding ruling to the Commission on that one, and I think it's just in the too hard basket. But once that goes over, if it goes to family protection, who's benefiting? You don't know. That's the whole issue, because it goes over there. And the reason it's going over there is the purpose isn't tax evasion. The purpose is asset protection from family law, family provisions claims and creditors. I mean, that's the reason you're doing it. So once you swing it all around, it really, that's the way that I would go. So I know there's been a lot of people up in arms, but I think the Commission is a bit on the back foot. Really what they should do is say, okay, well, if there's an issue on this, let's write some legislation around it, which is what they do in SMSFs. When they came out with that PCG 2016/5 about related party borrowing, because up until that time, you could do it till nil interest. Now, that was on foot for about maybe 18 months until they rewrote the legislation. So, and then they rewrote it too far, but that's what's always been the case, rather than the tax office trying to administer by fiat, particularly Section 100A, which was a trust stripping provision put in 1978 for the bottom of the harbour schemes. It's like, gosh, I think we've moved on in the last 45 years.
Yeah, there you go. I think their PR team looked over that one before it was released.
I know. Well, particularly when you've got a couple of cases of just run against you, it's like, oh my God, that you haven't got much of a hope. But look, the one that they did won, the Permi One case, I think it was, not Permi One, Prestige Motors. I mean, that was so dodgy. They had a unit trust, and then someone subscribed for the units in the unit trust, and then that went off to another business there. So that was quite clearly, it was a different way of doing Section 100A. So that one got caught, but that was like pure tax avoidance. Great scheme, but they picked it up through 100A. But yeah, what we traditionally see is a bit of concern. My feeling, I think personally, the one that I'd be worried about is that that OE's case, having to take into account the financial circumstances of all named beneficiaries, because that seems to be coming down the track like family provisions claims. They've even hit up people doing B2BNs down in Victoria, that if they haven't, what they do is that if they haven't taken into account all the potential dependents of the individual for a B2BN, what they've done is, what they're doing now is they're actually removing the trustees in OEs, they didn't go back and make the distributions void where it all went to that one child, because the stupid council didn't put that in. But what they did is they just got rid of the trustee going forward. In the SMSFs, they've got rid of the trustees. So what they're doing is they're looking at that equitable principle of everything has to be fair. So we've just got to be very careful that this is the mood of the courts around. And that what we need to do is, if you've got discretionary trust with named beneficiaries, it's a probably good chance to upgrade it to leading member bloodline style. So there's a theme there rather than having to worry about everything else.
Yeah, crazy. There you go.
Well, you have to work with what we've got, unfortunately. So, and things are changing. You can't, like the classic one, and NTAA still do it. Make sure you got all the assets in the non-risk spouse's name. And last year the Bosnack case, just the commissioner won, put a big home in the spouse's name. Commissioner won, and using the principles of equity, saying as a resulting trust, so that 50% of the home was actually held to be in the Mr. Bosnack, who'd been in significant litigation against the tax office, who then put a caveat on the property and have got full access to it. So again, even the stuff we were doing probably only 18 months ago, we need to rejig it and reinforce it and put it elsewhere, because you don't want something going wrong and then your client's saying, oh, you told me this, and then suddenly you find out, you're up the creek without a paddle.
That's it. And hey, we touched on non-refundable franking credits earlier.
Yeah.
You sounded like that's a pretty sure thing. Maybe not at this next budget, but could be at the March one next year.
Yeah, I think that there's that issue is, you look at if you look at it politically, and as I said, to get to that 43%, it's actually been shown we're going to have to invest $60 trillion, which, where's that going to come from? Even up here in Queensland, I mean, the state government, places going to recession, they're going to put in $62 billion, which is, they're going to have to borrow, and we all know borrowing costs are going up. So it's going to take money from elsewhere to do that. So they're going to start to have to look around the edges. The government won quite well, but there's a lot of those teal climate change people. So you think that, the opposition are probably not going to get in for at least 2 or 3 terms. So that means we've got really industry funds running the show, because they put their profits to the unions, and then unions pays it to Labor. So you see a gradual whittling around self-managed super funds, and again, those non-refundable franking credits. So that's going to be an issue. But again, they're probably going to do it the right thing this time. They'll just drop it and say, from this date onwards, that's it. And there'll be a lot of bellicose and all that. But I don't think it's really going to change many people's votes. Well, it'll change a lot of votes, but not their voters.
So I've got kind of 2 questions on that. My perspective is that's going to change where people put their money. That's kind of the first thing. Wonder your perspective on that. But also, do you think they're going to treat SMSF differently to the structure of super in an industry fund?
Yeah, well, they already have, effectively. I mean, if you have a look at the transfer pension balance, that was retrospective legislation, because a lot of people have built up quite sizable pension schemes. I was out there complaining about it, but no one ever really did. This was a coalition government that did that. Yeah. And they've actually said, sorry, from 2017, we don't care what's in the pension balance. You need to, put the rest in the accumulation. And here's a bit of a strategy for those of you who've got clients who've got large accumulation balances. Pull the money out, because it's tax-free, and gift it into or transfer it in to a family protection trust. And because you're paying tax at 15% in the accumulation phase, you can probably spread it out a lot further in the obviously the family protection trust, and likewise, you don't, if mum and dad both die together and it has to go down to an adult child, Lastly, you don't want to go to the estate, gets family provisions claim, it goes to adult child, they're up for 17% tax. So, do you know what I mean? You're better off just preempting it and going down and striking this out right from the start, which would be worthwhile. But, we're living in some interesting times. And, if you have a look at Europe, I think Europe's, they're going to have a very big basket case for a long time. They're going to drag down a lot of the world. I mean, you have to look at Germany. How many years do you have to wait to get a Mercedes-Benz on order now? It's crazy. I mean, they're industrial stuff, and that drags that down, and then that's going to have an impact. We're very lucky in Australia that we've got a lot of our resources, but it's that's going to have an impact. I mean, the government said, look, we're going to keep LNG for Australia, but at overseas prices. I mean, that doesn't make sense. So it doesn't make sense. And here again, and then again, we have like 70% of the world's uranium, and we don't have any nuclear reactors. Who knows? So we'll wait and see. But I think that we're in for they're going to have to tighten everyone's belt. I mean, ideally, the best thing to do would be to increase consumption taxes, probably put it on a broader range or extend the range. That in itself would have an impact on demand, which would reduce inflation potentially. It might have a bit of a blip in inflation, but it would reduce demand. But it's better because then that money goes to the states. The states would be happy. But whether they have the political will to do that, I don't know. I think the government's like, they're locked into these stage 3 tax cuts, which are good, but, where's the money going to come from? And the other one that overpinning all of this is that cohort. There's 5 million baby boomers in Australia who virtually all retired now. They're all going to be starting, or they're all virtually getting age pensions. Healthcare card has gone up, so they're all getting the healthcare card, even got a lot of money. And so, from that perspective, it means guys like you or clients, you've got to fund the baby boomers. And the Grant Institute did a fantastic paper on it and said, look, what you've got to do is introduce an intergenerational transfer tax, which is just death duties at 20% above $500,000. So mark my words, that's going to be coming at some stage. And so that's another reason having that family protection trust in play now. Then you don't want anything to go in the estate.
Yeah. Yep. Yeah. All right. Well, thank you.
That's a lot of stuff there, buddy.
It is, and I know it can seem overwhelming as advisors at some stage, sometimes. But if you are listening and it's something you haven't learned a lot about, then take those first few steps that we mentioned earlier.
Yeah,
definitely. Lean in. I suggest to the process.
Lean in and learn.
Mm-hmm. Absolutely. Well, thank you so much, Grant. I really appreciate you sharing, all the times that you have over the last few years. Our listeners would have got awesome value out of it. So thank you.
Perfect. Thank you.
Chat soon.
Ta.